Tillett, President of the City Club. Welcome to our Friday Forum. Today, on the subject of juvenile justice in Multnomah County. Our guest speakers today are Joanne Fuller, Director of the Multnomah County Department of Community Justice, Amy Holms Hehn, Senior Deputy District Attorney for Multnomah County, and Judge Elizabeth Welch, Circuit Court Judge for the Multnomah County. I'd also note that the Grant High School Constitution team is here in strength today. You're very welcome. And we expect some tough questions for you when we get to that part of the program. Next Friday, March the 8th, join us for a fascinating program related to recent studies of the brain in early childhood development with Dr. Patricia Kuhl, co-director of the Center for Mind, Brain and Learning at the University of Washington. And that will be here at the MAC. We're now halfway through our 2-month membership campaign, and by the end of March, we hope to add 100 new members to the City Club. So please pledge to recruit 2 members by completing one of the forms on your table and return it to the club office. For non-members, there are also membership application forms on the tables, so do please complete one and join this dynamic organization today. Some of the most important and influential work of the club is done by the issue committees. If you'd like to become more involved in any of the 6 subject area committees, you can find the dates and times for meetings listed in this week's bulletin. All you have to do is show up and take part. For younger members, the New Leaders Council also has much of interest to offer, as you may have gathered from this morning's paper. Call the club office for more information about the New Leaders Council. Our board host today, seated at the far end of the table, is Carol Witherell, member of the Board of Governors and Professor of Education at Lewis and Clark College. She will ask the first question of our speakers. Following Carol's question, we'll open the program to questions from the City Club members and high schoolers in the audience. Please get to the microphone ahead of time so that we can make the most of our panel's availability. Please identify yourself as a member of the City Club and ask your question quickly and concisely. Broadcast of City Club programs this quarter is made possible in part by corporate underwriting from Enterprise Rent-A-Car, from Pacific Care, and from Weyerhaeuser Company Foundation, and we're most grateful for their support. Joanne Fuller is Interim Director at the Multnomah County Department of Community Justice. She previously served as Deputy Director to the department, and before that was Senior Manager for Adult Probation Services. In the past, she ran social services for domestic violence victims and homeless women at the Portland YWCA. For 6 years, Ms. Fuller has chaired the Governor's Council on Domestic Violence, and she still manages to find time to teach at PSU. Judge Elizabeth Welch has been a family court judge since 1989 and a chief family court judge since 1993. Judge Welch is a member of the Oregon Law Institute Board of Directors and of the National Council of Juvenile and Family Court Judges. She also serves on a variety of boards, commissions and task forces concerned with juveniles, family law and probate, and is widely published on these matters. Amy Holms Hehn is Senior Deputy District Attorney supervising the Juvenile Division of the Multnomah County District Attorney's Office. That's quite a mouthful. She manages a team of 10 deputy district attorneys who handle delinquency, dependency, and termination of parental rights in juvenile court. Ms. Hehn has a special interest in child abuse prosecution and in juvenile justice issues. She's been actively involved in the Juvenile Alternatives Initiative, about which no doubt we shall hear today. So, ladies and gentlemen, please welcome our distinguished panel.
Thank you very much. I'm very pleased today that the members of the City Club are interested in what's going on in the juvenile justice system in Multnomah County. We have been involved in a process of change, as your bulletin informed you, and we're going to talk with you a little bit today about some of the elements of that change and what we hope are some of the results of it. Most of you can remember that or maybe actually given the age of this audience, some of you may not remember, but in the mid-1990s, there was a lot of talk about the upcoming generation of super predator kids. There were a lot of press articles. Time magazine put on the cover of their magazine an article about super predators. And there was this whole movement around believing that that there was a generation of juveniles that we were raising in this country that had no conscience, no empathy, and were just going to leave a swath of victims in their path. Fortunately for all of us, this never happened. Across the country today and in Multnomah County, we're seeing evidence of juvenile justice systems that are very effective, and juvenile offenders who were able to divert from extensive juvenile delinquency and work with effectively when they become involved in our system. There are some charts on your table that I'm going to explain and make sure that I explain in detail for our listening audience. But if you look at the pie chart, which is in the middle of that packet, you see that if we were to look at the population of juveniles 10 to 17 years old in Multnomah County, we would find that only about 6% of those kids are ever involved in the juvenile justice system. And about 1% of those youth are involved in what would be considered a violent offense, and only 0.3%, or 173 kids in 2001, are involved in Measure 11 crimes. This sometimes is surprising information for people because oftentimes audiences tell me that they believe somewhere between 20 and 40% of kids are involved in juvenile delinquency, and yet in reality it's a lot smaller number than many people believe. In addition to that, juvenile crime has been dropping dramatically across the country and in Multnomah County. From 1995 to 2001, we've seen referrals to the juvenile justice system in Multnomah County drop from a high of approximately 6,500 to last year approximately 4,000 youngsters who were referred to us. And when I talk about referrals in the juvenile justice system, that essentially equates to arrests in the adult system. Those are police contacts that are brought to our attention. In the juvenile justice system, we need to measure our success in a variety of different ways. The first way that we need to measure our success is in terms of public safety. And when I think about public safety, I don't just think about holding people accountable or locking people up in order to keep them from doing what they were doing, but I also think about changing behavior, because ultimately in this state, both juveniles and adults, anyone that we put away in jail or prison ultimately comes back out into the community. And if we haven't done everything that we can with people who are on probation and also incarcerated to change their behavior and change their opportunities, we're really not affecting public safety in the long run. In addition to that, we look at recidivism. So we look at public safety broadly, but then we focus specifically on whether or not people who've been involved, youth who've been involved in our system, actually commit reoffenses. And over the years from 1995 to 2001, looking at recidivism of youth in the juvenile justice system in Multnomah County, we find that we are hovering right around 32 to 31%. So what we're seeing is that while the population has dropped about 2,000 kids per year, the recidivism has maintained the same, but what that amounts to really is significantly less juvenile crime, significantly less crime at the front end, and significantly less crime in terms of the numbers of kids who are reoffending, because there's a lot smaller kids who are involved in this, number of kids who are involved in the system. One of the things that we're here to talk to you about today is how our system works and what changes we've been involved in the last few years. And I want to talk to you about the principles that our system change have been the basis of our system change. The first principle is collaboration. We have been, and I know this doesn't seem shocking to Oregon audiences, but across the country, a lot of systems don't work together. So the judiciary, the defense, the district attorney's office, and the juvenile department don't always work together. What we've done in our system is had a very broad-based collaboration. Not only the juvenile justice partners, but partners in the community, academic partners, partners in the business community, neighborhood associations, youth-serving organizations we've been working with those organizations to try to better affect what happens to kids who get involved in delinquency. We've based services in our system on focusing on the highest risk kids while trying to keep lowest risk kids out of the system. Research really tells us that where we're going to make a difference, both in victimization and reoffense, is by focusing our efforts on kids who are identified as highest risk for continued involvement in delinquency. So when you have a system that doesn't make that distinction and you spend all of your resources on the whole pool of kids, you really are involving sets of kids who are low risk in a lot of interventions that they may not need and that also may expose them to potential risk. We have detained youth based only on their risk to reoffend and failure to appear, and that has significantly decreased our use of detention, and I know that Amy's going to talk more about that. We've structured our probation supervision to include sanctions and services to kids who are on probation so that they are able to, our probation officers are able to work on changing kids' behavior, not just watching kids fail over and over again. We also have significantly lower caseloads for probation officers than many parts of the country. I talk to many department directors around the country of juvenile justice departments, and oftentimes they have caseloads of 75 to 100 per probation officer. I really, frankly, don't know what you do with 100 kids on a caseload as a juvenile probation officer. You probably don't know all of those kids individually. You're certainly not able to have a relationship with them or be involved in the life of the child and their family. Here in Multnomah County, we have caseloads of somewhere around 25 to 30 as a typical caseload for a probation officer. That's much more reasonable to expect that the interventions that you're involved in probation are actually going to make a difference. In addition to that, we've worked with a variety of treatment systems to meet kids' needs. It just makes sense, I'm sure to all of you, that many kids who are involved in our system have a multiplicity of problems. Delinquency isn't the only issue that they've got, and they need to be involved in drug and alcohol and mental health treatment as appropriate and interventions with their family. In addition to that, we've looked at the best practices literature around the country, and we've implemented a set of programs that are proven to be effective at addressing delinquency. One of those is a program called Multisystemic Family Therapy, which is an intensive intervention with kids and their families where therapists actually go into the home instead of bringing the kid into the juvenile department. These changes have had a huge impact on the outcomes of kids in our system. However, and we believe that justice is being better served and we are also more effective with the kids that we're working with. However, there are still many issues that we need to address or that we need to address more deeply. We need to be more effective in terms of working with youth of color. We have created a set of services specifically designed for youth of color. Minority youth are overrepresented in the juvenile justice system here in Multnomah County and across the country, and Judge Welch is going to talk about that. But what we have to do is really hone in on what are the strengths that minority communities bring to the table and how we can catalyze and utilize those strengths in a way that can help to better serve kids who come to us from minority communities. We need to work with a variety of community organizations to make sure that those kids that come from minority communities in Oregon are getting their needs better met. We also have to we began to look at the changes in demographics in Multnomah County, and most of you are aware that the demographic is really changing so that the Latino community is growing and the number of Latino youth is growing in the community. And as we look into the future, we need to think more about how we're able to serve a bicultural, bilingual population or monolingual Spanish population here in Multnomah County to better intervene with those kids. We need to do a better job of programming for girls. Girls are usually about 20% of the population in the juvenile justice system, and we need to make sure that that 20% doesn't get lost in the needs of the 80% that are boys. And sometimes that's difficult because in a system like ours, we have about 700 kids on probation right now in Multnomah County. And so in a system like ours, that means that that isn't actually that many girls. And it's hard sometimes to program for such small slices of your population. However, we need to figure out ways to do that because girls have particular needs that we have to address. We need to continue to improve and refine our services to become more strength-based. Across the country, strength-based practice, which means that you focus on the assets that a family brings to the table as opposed to just the needs. Is strength-based practice is becoming the practice of progressive agencies, and we need to focus more on that strength-based practice here in Oregon. We are fortunate soon we expect to be receiving a grant from the Robert Wood Johnson Foundation to help us work on that strength-based practice model. Strength-based practice is a lot what you would do with your own kids, which is that you wouldn't always focus on the problems, you'd also focus on their strengths and building those strengths. And then we really need to work with community organizations like your own and other community members to help the community to own these kids as their own. We cannot look at kids who are involved in the juvenile justice system as somebody else's kids. We have to understand that they're members of our community and that all of us have a responsibility to reach out to those kids and to embrace them, to pay taxes on their behalf, to make sure that we're funding the services that they really need, and to create community public-private partnerships and other kinds of enterprises to attach more services to kids whose families aren't able to provide them what they need to develop fully and to become the kinds of adults that we would want them to be. Thank you.
Good afternoon. In about 1993, Multnomah County's juvenile detention facility was the subject of a federal lawsuit in which there was a consent decree that the facility needed to be upgraded and services in the facility needed to be upgraded. And about the time that the county decided that they were indeed going to build a new building and a new facility out at 68th and Halsey, Annie E. Casey and company came to town. You all have heard of Annie E. Casey Foundation. They give away a lot of money to communities on family and justice-related issues. And they came to town peddling a very earth-shaking concept. Now, when I tell you what it is, you're not going to think it's very earth-shaking, but it is. And the idea was that while you're sort of planning your new facility and how you're going to manage it and build it and pay for it and all that stuff, that you might want to consider having what we call now a RAI. That's an acronym for a risk assessment instrument, an objective process for measuring who needs to be in detention and who doesn't need to be in detention. Now, for those of you who are not familiar with the criminal justice and juvenile justice system, allow me to assure you that objective measurement devices are not common. That's a kind way of putting it in this system. So that's why it was earth-shaking. And the reaction was, oh, maybe we'd look at that. So we did. We looked at it and we developed, and the idea was that each community was to develop their own way of doing this. It wasn't a predetermined do it this way. And so this device was put together, and there are now, we're now on RAI 3. Actually, it's really RAI 4, but it gets changed. It's not a set instrument. And it's worked. It's worked beautifully. The purpose of detention is to prevent reoffense and to make sure that the individual will show up when they are supposed to be in court. Those are the law of Oregon says, and the law in most places say, that kids are supposed to be released unless, in other words, there's a presumption of release unless there's a risk of one or both of those things happening. So the issue was, how do you measure that? So the people who knew that the best, the people who work in the juvenile department, put together this risk instrument. We use it, and lo and behold, it worked. In 1993, the average daily population in the Multnomah County Juvenile Facility was 96. Today, and for I think the last 2.5 years, maybe 3 years, it's been 20. We've closed 3 detention pods, or 2, saved millions of dollars in that process. But that wasn't the purpose of doing it, and that's not the best part about it. Children are not just released outright. They are released into different kinds of programs different levels of supervision, but they are at home or in foster homes in some instances, usually at home, but they have reporting responsibilities and they have to be, we keep track of them. And we have some new data just today that we keep looking at. How is this working? What are the bugs in it? What needs to be changed? But as Joanne Fuller has pointed out to you, the crime rate has not gone berserk, and the incidence of problems with these kids has been very, very acceptable. And the real acid test, of course, is do kids fail to appear or reoffend while they're awaiting trial on these charges or disposition of the charges? And the answer is that the numbers are extremely low on both reoffense and failure to appear. They're not zero, but there's no expectation of zero because we're dealing with a whole range of kids of different levels of disturbance and problems. By national standards, extremely low numbers. And that's great. Nobody, I can tell you this, because we are as Joanne was mentioning to your president here, we are now the place to copy nationally in terms of this little device that we use. Nobody is anywhere near where we are on this. But here's the real exciting kicker. Not only did we accomplish what we set out to, what we hoped would occur by doing this, and what Annie E. Casey Foundation hoped we would accomplish, but we accomplished something else, or something else has happened, I guess I should say. Before we started this process, an African American youth was 2.5 times as likely to be detained as a white kid. Now, I want you to understand what I'm talking about here because the press covered this about a month ago and they didn't get it quite correct, okay? We get X number of kids delivered to the door of the building. We're talking about that group as a given. Of those kids is what I'm talking about. 2.5 times, black kids were 2.5 times as likely to be detained. Hispanic kids, 1.5 times as likely as white kids to be detained. Those numbers are very unrespectable. As a result, we believe, of this device, all racial groups are detained at the same rate. We've known this for years now, a couple years, and like now when I just told you this, it still just makes my heart stop. This is very exciting. And what it tells us is, and we can talk for hours about what it maybe tells us, but what it tells us is that this device and this concept have a lot of potential for bringing about real justice in this system. Now, that is not to say that there is not minority overrepresentation in detention, because you have to go back to who got brought to the door. And black kids and Hispanic kids and Asian kids get brought to the door in numbers totally out of relationship with their percentage in the population. And I am not trying to suggest to you that that problem has been solved. It has been minimized by this device being applied to the kids who are brought to the door. But now, of course, we are totally infected with the potential value of what we've learned. Now, there's one of the first things and the heart and soul of the juvenile justice system is what's now called diversion. It had in earlier days, it had different names. And this is situations where children are not adjudicated. They are not formally charged, or the decision to formally charge them is changed because they are usually first offenders. The offenses are not serious, a variety of things, but those are the main items. And we took a look at who gets to go to diversion. Because again, this decision was made the way all the decisions in this process, very elaborate process, are made. They're made by trained, experienced people, human beings making decisions on a case-by-case basis. And we looked at the diversion statistics, and lo and behold, African American kids do not have the opportunity to be diverted as much as white kids do. Now, one of the things that would immediately pop to many of your minds is, What about the seriousness of the offense? Is that the reason why maybe black kids or Hispanic kids or Asian kids commit more serious offenses? Controlling for the severity of the offense did not eliminate the disparity. There's a disparity there, the same perhaps that we adjusted with our ray. And so now we have we don't call it that, but now we have a ray for diversion. We have written standards about who gets diverted and what the rules are and who doesn't. And we're moving through the process. There's another step. It's another form of diversion. I don't want to take the time because I don't have much to tell you about. But I want to get to the real cruncher here, the real challenge. We had a theory, and when I say we, that's not the royal we, it's the people in the system, most of us, that black and Asian kids, particularly from Portland, were not getting into residential treatment programs outside the metropolitan area. Now, you need to understand, because this is a very important basic thing about the way these systems function, all those programs out there are paid for with tax dollars. So somebody who's running a program to treat kids with alcohol and drug problems in Multnomah County, whatever, they get their money from the Oregon Youth Authority, but the people who run that program get to decide who comes into their program. That's a very important piece of information for you to sort of store, right? Okay, so we said to the Youth Authority, we brought them into our working group and we said, we think this is the case. And they said, we think it is too, but let's look at our numbers and see what they look like. And they came back and our hypothesis was slightly incorrect, was significantly incorrect. Our minority kids don't get into programs anywhere. They don't get into the programs in Multnomah County that provide residential or community-based treatment. So what we have is the second real crunch here, and that is, how do we fix that? How do we change that? Now, one of the reasons we want to change it, other than the obvious and basic reason that we want to have a system that is just and fair, is that if we know that this kid needs X, drug and alcohol treatment, mental health treatment probably being the two most common, and the kid does not go into a program because they're not accepted or there's too long a waiting list, basically what happens to that kid is that they go home. And you know what else happens? They continue to offend because they're not getting the services they need. And so pretty soon this kid's got a nice, big, long record. And guess where they go? To the state training school. So we believe that that very significant minority overrep in the state training schools is at least partially to be explained by the lack of access of minority kids to the alternative programs operated in the state for their benefit, but that they don't get. And they don't get, and I'm not saying this is a total situation by any means. They don't get into those programs for the same reason that other kids don't get into the programs, and that is we don't have enough services. That's a given. But also because there is this phenomenon that we're beginning to try to define and build a wall around and learn about and fix. I've been involved in this kind of stuff in one way or another for a very long time. This is the most exciting, important undertaking that I've ever been a part of. And I hope in this short time that I've been speaking to you that I've gotten your attention and your enthusiasm. So I will pass the gauntlet to my colleagues.
Good afternoon. My name's Amy Holms Hehn, and as I was introduced, I'm the Senior Deputy District Attorney in charge of the Juvenile Unit of the Multnomah County District Attorney's Office. And I've been a prosecutor for about 14 years. I supervise a team of attorneys who handle what we've been talking about here today, which is juvenile delinquency prosecution. So that's prosecution of youths who commit crime. But our unit also handles what are called dependency and termination of parental rights cases. And those cases involve children who need the protection of the court because their circumstances endanger their welfare in one way or another, either because of abuse or neglect or some other problem. So I and my teammates have definitely a very broad and deep perspective on the problem of crime, about where crime comes from, and a very broad exposure to troubled children and families. I hope you have a sense in listening to Judge Welch and Joanne here today that those of us who work in the juvenile justice system have a real passion for this work, and I certainly share that passion. And my passion comes from a couple of different places. It comes first of all because, I'm a mother of 2 small children. I'm a native Oregonian. I live in the city and care about kids in my community. But I'm also a veteran of adult-side criminal prosecution, and I've handled many very serious person felonies, sex crimes, serious assaults, homicides, child abuse cases. And that work is very important work to community safety, but it doesn't take doing that work very long to begin to really ask questions about where crime comes from, and to ask if we might not do a better job of identifying kids who are at risk of engaging in serious violent behavior earlier on, and trying to intervene in their lives at an earlier stage to try to prevent crime and try to prevent the sort of heartbreaking victimization that you see when you're prosecuting a serious violent offender in the adult system. So as a prosecutor, the juvenile justice system is exactly where I want to be and where I think I need to be in order to make the most impact that I can make on the problem of crime in our community. We're very lucky here to have our district attorney, Mike Shrunk, and our Board of County Commissioners also very committed to the importance of the juvenile justice system in the broader picture of crime prevention and justice generally. I think in order to appreciate what you've been hearing from Joanne and from Judge Welch today about where we are today in juvenile justice in Multnomah County, you have to have a little bit of a sense of where we've come from and how far we've come. As Joanne said, in the early 90s, we were a system in crisis for a variety of reasons. Juvenile crime and crime generally was climbing dramatically to a peak in 1993. The juvenile justice system was faced with very much younger youths committing much more serious crimes than before. We began to be very concerned about kids and guns. And the juvenile justice system was founded historically, now 100 years ago, on the principle of the court being a safe haven and a refuge for children, a court of protection for children. And in many ways it very much still is. But when we began to be faced with serious violent offending by juveniles in the early 90s, the system was revealed to be inadequate to the task. Its focus by statute was on the best interests of the youth. And while that is an important element, unfortunately, in the view of many people, interests of victims and concerns about public safety and the welfare of the community were given a back seat very much to protecting the offender. In addition, our system was disorganized. The practices that we were employing were not based upon research or about information about what works to change youth behavior, but much more based upon what had been done in the past, upon intuition, upon gut instinct, and upon essentially unexamined ways of doing business. So, not surprisingly, the system began to lose credibility, and it lost credibility primarily with prosecutors and with victim advocates who felt that the juvenile justice system was not taking serious violent offenders seriously. And it also lost credibility with the public, which is why we now have Measure 11, which many of you are familiar with. So in 1995 or thereabouts, there was really a revolution in the juvenile justice system. There were some major statutory changes which really righted the balance in the system to one now which we call a system of balanced and restorative justice. So rather than being primarily focused on the best interests of the youth, now the system is required to be balanced. And that means while the best interests of the youth is very important, the interests of victims and of community safety are very much on a par with the interests of the youth. Our hope is that all of those interests harmonize. Those are not dichotomous, but rather things that work together. And there were many other changes which brought about a system that was much more organized and accountable. One of the big changes was, I think, a change in leadership. Judge Welch became much more actively involved in juvenile justice. Joanne Fuller and her predecessor, Elise Clausen, became leaders in the juvenile department, and we began to move towards the system that we have now, which is a system which is based on a very critical examination of each and everything that we do. And what we do is we ask ourselves, what is our goal? And our goal is to change youth behavior, to prevent offending and to prevent reoffending in order to reduce juvenile crime and help keep the community safe. So we were clear on our goal, and we constantly ask ourselves, are the things that we're doing actually having a concrete impact and actually designed to achieve that goal, instead of just assuming that they are? As a result of this now, we have become, as Judge Welch said, a national model for juvenile justice practices. And that's because we've done research to try to find out what sort of interventions actually work to change youth behavior. We look at data every day to examine what we're doing and to make sure we can actually document results and make sure that the things that we're doing are actually effective. I do believe that the changes that we've made in juvenile justice are having a positive impact. Juvenile crime has declined steadily since 1993, and there are a constellation of factors, I think, which have contributed to that. But I have to believe that doing a better job earlier on is making a difference. I do want to briefly mention this issue of the use of detention, which Judge Welch raised in her talk. We have greatly reduced reliance on detention as a tool in our system. And we've done that, as Judge Welch said, by structuring decision-making at the gates of detention so that people who are admitting youths to detention are required to focus on only legally relevant factors. That means youth's risk to reoffend and their risk to fail to appear for court if they're released. But it's also involved providing effective pretrial supervision alternatives for juveniles so that it's not simply a decision about whether to release or to hold a youth, rather what level of supervision is necessary. And as the judge said, our average daily population in juvenile detention now is 20 youths in a facility that has a capacity currently of about 100 beds. And that has allowed us to liberate several pods in detention, we call them, for secure treatment for kids who need secure drug and alcohol treatment. And we also have a secure sex offender treatment program in detention, which is also a national model and unique nationally. And this is important because detention doesn't work for all youths if our goal is to change behavior. We need to remember that many of the kids that come to our system have experienced much harsher punishments in their daily lives than we could ever inflict by putting them in detention. And so stepping away from reliance upon detention as a tool forces us to actually ask the question, why is this youth behaving in the way that he or she is, and what is most likely to actually make a difference in their behavior, and to look for more creative strategies. I think in the past we looked to detention and used it as a tool because we lacked any other ideas about how to change behavior, and we sort of felt like locking them up was the only real answer. When what we found is that with the vast majority of youths there are other strategies which are more effective. Bear in mind, though, that detention is very much necessary, very clearly necessary for some juveniles in our system. Kids who engage in serious violent behavior that endangers the people in our community or who have seriously victimized others, kids who pose a serious risk of fleeing or not returning to court if they're released, and also kids who pose a risk to themselves that is so great that they can't be managed safely in a less restrictive setting. But what I want to point out is that against this backdrop of a great decline in the use of detention, crime rates have also declined dramatically. So locking up fewer kids who are the less serious kids in our system has not resulted in any sort of compromise of public safety, but rather has enhanced public safety. As Judge Welch mentioned, these findings about disproportionate minority confinement and detention were a big eye-opener for all of us, and for me personally. I think that I never would have wanted to believe that bias was in any way playing a role in our system, because I know the people in our system, and I know them all to be well-intentioned people who are really wanting to do the best thing for the kids that come through the doors of our system. But I think what we found is that unintended bias can affect people's decision making, and that you need to impose structure and standards around decision making at key decision points in order to ensure that all youths are treated similarly. And that is now the approach that we're trying to take to each and every decision point in our system. So as far as the goals for the future, I very much echo the goals that Joanne and Judge Welch set forth about what we need to do. I want to add a few things to that list. I think that we need to continue to be more responsive to the needs of victims in our juvenile justice system. It's very important to us in the district attorney's office. I think that it is becoming more and more important to other actors in this system. We need to help victims feel included. We need to be sure that their restitution is paid and that they have an opportunity to feel like they are made whole. And we have a ways to go in doing that, I think. Victims historically in the juvenile justice system have really not been paid much attention to, and I think have been viewed as more of an annoyance than anything sometimes in the past. I'm also very concerned about the lack of secure residential mental health treatment facilities for kids who have very serious mental health problems, because all too often I think they end up in our youth correction facilities because of a lack of good alternatives in the community. Two other things. I think that I'm very concerned about what I hear about potential cuts in funding for the Department of Human Services, which used to be the State Office for Services to Children and Families, and before that, CSD. And I say that because working in the system as I do on the dependency side as well, with kids who've been abused and neglected, I'm very aware of the links between exposure to abuse and neglect, to family violence, to substance abuse, to later involvement in criminal activity. And so I think that we're very short-sighted in terms of the bigger picture of crime reduction and quality of life in our community if we don't invest in children and families at all levels. And to follow up on that same point, I continue to be shocked and dismayed by the lack of stable school funding in the state of Oregon. I grew up in Oregon, grew up in Medford, and when I was a little kid, we were still fighting over how we were going to fund our schools. All of the data that we in our system know about tells us that there is no better crime reduction strategy or crime prevention strategy than making sure that kids stay in school and that schools are rich, supportive environments from which all kids can fully benefit. So until we take that bull by the horns and develop a system of stable school funding, I think we'll continue to struggle in our system with crime and delinquency. So those are the things that I wanted to say today. It's a very inspiring time to be working in juvenile justice, as Judge Welch said, and our goal is just to continue to examine what we do every day and to try to do a better job every day, and we welcome your ideas, your input, and your support. Thank you.
Amy, your last plug for supporting the schools answered or gave me one answer to my question, but I'm going to look for others as well. What are the systemic issues of access and equity along the lines of race and economics in our region that you believe can be addressed by all of us that could lead to healthier families and communities and further reduction in crime? And that's a beyond services and programs question.
Boy, I would really like to kind of kick that question over to my colleague, Joanne Fuller, because, not because I don't care about the issue, I do very deeply, but I think she's probably able to give a more informed answer, because this is a question she has thought about and worked hard on for many years now in our system.
Yes, I think that you ask a really good question, because what Judge Welch was talking about is improvements that we've made in our system to try to address the problem as we feel like we own it, the piece that we own. And the issue of minority overrepresentation in criminal justice is embedded, I think, in a broader set of issues that we all have some responsibility for addressing. There's a couple of things that I think I could highlight. One is that I don't think that you can separate the fact that we have minorities overrepresented in both the adult and juvenile criminal justice systems from the fact that minority communities have not benefited from economic development as much as they could have. that we need to look at whether our schools are as effective with minority youth as they are with majority youth, and make sure that the same schooling opportunities, as Amy said, schooling and completing your schooling is a huge factor in kids not becoming involved in delinquency. There's another issue that I think we have to take a look at in this country, which is that we have incarcerated huge numbers of African American men in our prisons, and that deprives them of their voting rights if they've committed a felony in most states or across the country. And it also means that they're not present in their community to be involved in being fathers, being involved in the economic and the social health of their community. And their communities oftentimes struggle, and the individual families struggle as they return. So I think that we also have to take a look at our policies. I said at a recent conference about minority overrepresentation that I feel like we've looked to the criminal justice system to impact social problems in Oregon, and I feel that in Oregon and in the nation, and I feel that very strongly. The criminal justice system is not the ultimate solution to social problems, and I think we have to turn to other systems and other economic and policy development to try to address some of the problems that we have. There's a lot of strength in the minority communities, the communities of color in Oregon. I think that the dialogue between the majority community and those communities needs to be sustained so that we can talk to them about what they feel like they need to build the most thriving community that they can.
Gwen Vermillion, City Club member. Mike, I have a number of questions. It's a very interesting program, and the people at my table at least really want to know more. The first thing I wanted to know is what kind of special programs do you create for girls, and have you come up with any considerations for them in this program? I know you're still working on it, but how do their problems differ from your male offenders, and how are they treated differently in the system now?
Joanne. There's a couple of things that distinguish girls from young male offenders. Historically, at least, girls have been more prone to involve themselves in behaviors that are more personally injuring themselves, self-destructive, as opposed to harmful to other people. We've seen a slight increase in girls actually being involved in more serious crimes of hurting other people in recent history, which is really sad to me. But we still see this pattern of girls who do a lot of self-destructive behavior. The other reality is, and we don't have very good statistics about boys around this, but we have pretty good statistics about girls. Almost all of the girls who are involved in the criminal justice system have been abused. And so what we're really looking at when we work with those girls is a girl who is an abuse victim, either physical or sexual abuse victim, oftentimes at a very early age. Many of them ran away from home, oftentimes behind that abuse, and are very angry and very much affected in their relationship with adults because of that abuse. And we can't, we have to address that while we simultaneously hold them accountable for whatever is the delinquent behavior that they've got. The other thing is that I'm not sure that our educational institutions always meet the needs of girls, and we see a lot of girls who begin to fall behind in school at various points or leave school because of a lot of peer and social pressures, and I think we need to figure out ways to address that. Part of how you serve girls is one of the same strategies that I think is most effective with boys, which is individualized programming. You can have the best, the most effective proven practices in the world, but if you aren't customizing that programming to meet the needs of the kid in front of you, you probably aren't going to be able to reach that kid. The other thing that we know about girls programming is that it needs to be relational. The research out of the Stone Center tells us that girls girls' emotional development is very relationally based. And so when they come from homes where they can't create a good, strong bond with a caring adult, which is also important to boys, that they then are not going to be able to really mature and develop in their thinking and their social maturity. And so part of the best strategies for girls are to have programs that are intensive and that create those relationship connections, oftentimes to mentors who can maintain those relationships beyond the girl's involvement with the juvenile justice system.
Bill Savage, City Club member, could you, I'm not sure which one, but someone comment on Measure 11? Is it helping or hurting?
I'll dive in and try to address that question. Let me just say, I don't handle Measure 11 offenses. I'm a practitioner in the juvenile justice system, and Measure 11 offenses are charged in the adult system. Is Measure 11 helping or hurting? That's a big question. I think that to answer questions about Measure 11, we have to remember the history, how we got Measure 11. And I talked about that a little bit before. And that was, and I don't think anyone here on this panel would disagree with this, as much as they may disagree with the idea of Measure 11, that we have Measure 11 because of some serious problems in the juvenile justice system, taking serious violent offenders in the juvenile system seriously. And people just got fed up with it. I think people just felt like kids were walking on offenses which caused serious harm to other people. So Measure 11 has sort of plucked off the top of the juvenile justice system the older, 15 years of age and older, juveniles who commit the most serious violent offenses, and those include rapes, robberies, other felony sex offenses, serious assaults, that means assaults with weapons or which inflict permanent or serious physical injury on people. But I think another thing to keep in mind is the scope of Measure 11 as it impacts juveniles. Our office publishes statistics every month on Measure 11, and they're available to any of you from our office if you were just to ask us for them. And since Measure 11 became effective in April 1 of 1995, there have been 586 juveniles indicted under Measure 11. That's really not very many people when you think about that span of time, and put that against a backdrop of, at that time, some 6,000 referrals a year to the juvenile justice system, now down to, in the neighborhood of about 4,000. And I think it's also important to remember that the statistics show that a little over 1,000 Measure 11 cases were referred to our system during that same time period, but close to half of them were rejected for Measure 11 prosecution. So there's a lot of quality control, I guess you would say, at work, trying to make sure that those cases which really go forward as Measure 11 offenses are ones that really need to go forward. Finally, the vast majority of juveniles charged with Measure 11 offenses ultimately are able to receive a negotiation from our office which results in a non-Measure 11 sentence being imposed. And then those juveniles are not sent to adult prison typically, but rather to youth correction facilities where they are allowed to receive treatment and other services designed to, as Joanne said, to help them return to the community safer and better able to be successful without reoffending. So while Measure 11 was a very important thing, a big change in our system, in terms of the number of youths it's really impacted in the big picture of the juvenile justice system, it's relatively small. So I hope that answers your question. Thank you.
I guess the one thing that I'd like to say about Measure 11 that has always concerned me is that the way that we constructed that law, it allowed us to scoop up first-time offenders and kids who hadn't had a lot of other interventions before to mandatory sentences, which in Multnomah County, I don't have the statistics in front of us, but we've had a fair number of kids who've been involved in first-time offenses or had very little contact with the criminal justice system prior to committing a Measure 11 offense. And I think that one of the things that we have to struggle with as a society with a shrinking resource for public intervention is where mandatory sentences fit into that, because mandatory sentences means that the judge has no discretion and we're required to send the kid to the state institution at a significant cost for oftentimes a significant period of time, and whether or not that's the best intervention we can provide. So I agree with Amy about historically where it came from. I think the juvenile system, at least here in Multnomah County, has proven itself to be able to hold kids accountable, and so we've, I think, got a public policy that comes from one time period that we're now applying to another. And Amy knows we don't always agree when it comes to everything. So
I do want to this isn't point counterpoint, but I do want to just add I understand what Joanne is saying about the concern about first-time offenders, but the other way to look at that, and I'm not saying this is the right way to look at it, but this is something just for food for thought for those of you who are thinking about the issue of Measure 11. If you're seriously victimized by a juvenile who commits a Measure 11 offense, if you're the victim of a rape or an armed robbery or a serious assault with a weapon, it really doesn't matter to you very much that it's a first-time offender. You're just as victimized as if the youth had 10 prior offenses. And so that's something to keep in mind from the victim's perspective. Also, ask yourselves, what is an appropriate consequence for behavior like that? That's a very difficult question, I think, for any of us to answer. What is enough of a punishment or enough of a consequence for someone who is inflicted, serious or even sometimes permanent harm on another human being? That's, that problem is sort of at the core of sentencing theory. And so all of these very difficult questions are at play when we talk about whether Measure 11 is good or bad. It's a complicated question. So.
I wasn't going to say anything. I'm not supposed to.
The judge always gets the last word. Yeah. We know that.
My answer to that wonderful final point is give the decision back to the people you chose to make it in the first place, elected judges.
Brian Wagner, the state champion Grant High School Constitution team.
Yay!
Yeah, I've been told we need $30,000 to go to Washington, D.C. So, my question was, how does the breakdown of race in the juvenile justice system compare with the adults for referrals and then also for final sentencing? Is it about the same, or are there skewed numbers in different proportions?
I don't have the numbers in front of me. The people from my office who do have the numbers are here, and I'm sure that they'd be happy to talk with you about the specifics. I can tell you that they're both skewed, and for both coming into the into the system, and they're both skewed somewhat in terms of sentencing. So I'd be happy afterwards to give you more information about that. But in both systems, we need to, whatever the numbers are, they are appalling, and we need to continue to try to work to do something about them.
Tom Hogan, City Club member, thank you very much today. Joanne mentioned more work with community organizations such as the City Club, and this is really a question for the whole panel. Do you have any specific ideas, or have you specific notions of how the City Club could be more involved in the next steps in this important subject that you've talked about to us today?
Go ahead, yeah.
I tried to think about that in the last few days because I've realized that was undoubtedly going to come up. I should keep doing this. Okay. One of the big issues in juvenile justice that has been referred to slightly but needs to get its chunk of time is mental health. I think going to national conferences, which I do very, very little, but when I go, it's just so startling. From my most recent experience was a very large meeting in Atlanta. The juvenile detention facilities, the juvenile correctional facilities are all over this country and in this state are filled with kids with mental health problems. And the reason that they are in these facilities is there isn't anywhere else for them to be. They don't belong there. They belong in mental health programs. We don't have enough of any kind of mental health programs. We have virtually no programs for girls and very little for boys, much less the other issues that I've raised today. So if there was a subject to take on, it would be the subject that Don Clark was involved in with, 30 years ago? Yeah, 30 years ago, of the lack of community-based mental health resources for children. There's never been any significant amount for children. There have been some for adults, very little or none for children. So that's an area that I would hope maybe you could, and I see some people in this audience that would love to put some effort in that, I'm sure.
Patty was also telling me before we started that you have a committee that's working on looking at drug policy, and I think that that's drug policy as it relates to juveniles is another big issue. We're spending a lot of money in both the juvenile and adult corrections system working with people who one of their fundamental core drivers of their behavior is substance use and abuse. And I think that making sure that we're using our analyzing and making sure that we're using our public dollars wisely in our interventions with those folks makes a real significant difference. The other thing is less of a city club per se. Well, there is a city club role here. I think that very few people in our state understand that when we talk about budget cuts, they think we're talking about cutting bureaucracy or cutting government fat or something or other. And what we're talking about here today with you is good government and good government at work. And I think figuring out how to help government be better and get the message out about what good government really looks like is a role that the City Club has historically played, and I think that you need to continue to play, and that all of us need to step up that message in this world where people feel like they don't want to pay more taxes because they're not sure what they're getting for those taxes. And that's partly our problem too in government, and not explaining to people what they're really buying.
I'd like to add just one. I agree completely with what both Joanne and Judge Welch have said. One further thing I would want to add is that when I look around this room, I think there are probably lots of people who could provide great mentorship opportunities and employment opportunities for youth in our system. What we find with the youths that come through our doors is that many of them have never really had a caring adult in their life, or a person to support them or tell them that they're doing a good job or give them an opportunity to succeed. And I think that there's probably a wealth of resources here, people who could really offer that to young people, because again, looking at data, the ability or the opportunity to bond with a caring adult is one of the most important tools or one of the most important pieces that is necessary in order to help youth succeed.
Betsy Warrener, City Club member. I'm very interested in the criteria that differentiate youth who are at high risk of reoffending versus low risk. And I was wondering if you're able to share with us any of the items from the RAE.
Sure. What we look at with the RAE, we look a lot first at history of offending, because the history, the severity of the presenting offense and the history of the previous offenses are two of the most important factors in looking at risk to reoffend. Then you also want to look at whether or not the kid has failed to appear before because if they have failed to appear before, it's pretty much likely that they're not going to appear again before the court. And so those are some of the key factors that we look at. In addition to that, we look at information that we have about the school and whether or not the kid is complying with expectations that are currently in the kid's life. But what we don't look at is things like, does this kid have a gang identifier? Because lots of times kids have gotten gang identifiers because they live in neighborhoods that are infested with gangs, or they have some friends that are gang members, and they have been scooped up into that identification, but they may or may not be involved in a gang. We don't look at things. We don't look at things like, does this kid come from an intact home? All of those other kinds of things. Those may be need issues or factors that we would look at in long-term intervention with a kid. But when we're making that decision to detain or release a kid in detention, we want to be really honing in on just some specific things that are about, is this kid going to make their court appearances in the next month? And, are they going to immediately reoffend in the next month, and make that decision there? And then look at need and other kind of psychosocial issues for the longer-term involvement with the kid.
Good afternoon. My name is Vera Poole. I'm candidate for sheriff of Multnomah County. I have a question for Judge Welch. I'm really impressed with the information you shared with us this afternoon. The risk assessment tool, very effective tool for juveniles. Do you think that risk assessment tool would be effective for adult criminals who are in the criminal justice system? I worked for Multnomah County Sheriff for over 31 years, and we house over 2,000 adult criminals daily. And if that system is working for juvenile, share with me how we can make it work for adults. Thank you.
You bet. I certainly can't speak in very specific terms. I am pleased to be able to say, however, that this issue is actually being discussed, seriously being discussed. Judge Julie Franz, who's the chief criminal judge in Multnomah County Circuit Court, has had a series of meetings where the exact issue of why can't we do this with adults, and the sheriff's office has been involved in those discussions, as I understand it. I have not attended those meetings. That's their problem. I got enough other stuff to deal with. But it is being looked at, and so when I speak any further than that, I'm just expressing my own opinion. I don't see any reason why